Welcome everybody. This is Associate's Guide, Best Fiduciary Practices. I'm just curious, anybody here been to last year's other programs on our Associate's Guide? Yes? Oh, good. I'm sure we have some people out there in TV land. And the Associate's Guide, it's meant for very basic review and to get a good foundation in the area. It is my pleasure to be presenting this program with one of the best estate litigators I know, Ann Bederka. Let me tell you a little bit about Ann. She is a member of Greenfield, Stein & Senior here in New York City, which is a trust and estates litigation boutique. She previously served as a principal law clerk to the retired surrogate Kristen Booth Glenn in the New York County Surrogates Court. That's right here in New York City. She is the co-author of Harris 6th edition New York Estates Probate Administration and Litigation. For 2012 and 2013, she was a panelist for the New York State Bar Association Certified Training Program, What You Need to Know as a Guardian Ad Litem. She is a court-appointed referee and guardian ad litem in a range of surrogates court matters, and she's a former adjunct professor and current guest lecturer on probate litigation at Fordham Law School. And she's helped me out on my course that I do, my wills and trust course, my estate litigation unit, and it's wonderful to have her here. As part of all of my programs, my goal for each and every one of you is that you will remember just three things. I mean, three things, but in 6 months' time. So, I mean, we all go to, great lectures and hear wonderful things, and, 2 weeks later, what is it that, and try to recall a specific thing. So as Ann and I are going through these materials, we're going to try to highlight some of those things. So that way you can kind of make a mental note, so that way, in 6 months' time, you'll have remembered three things. There's a couple handouts that have gone along with tonight's program, so let me just kind of give you a brief overview. So the first handout is just kind of a little bullet point guide to our program this evening. It has Lawline on top. The second two materials are outstanding materials done by Ann. And I'll just let you mention, both of these.
Remind me. Got one handout on discussing generally the guiding principles in meeting fiduciary obligations with a focus on investment obligations. And the second focuses almost exclusively on ethical issues that relate exclusively or most particularly to trust and estates legal issues.
Okay, great. And the last handout, and some of you may have, for some of you have been to my earlier program on estate administration, but we're going to be drawing on it today because I see we have a lot of people that may have not taken our earlier programs. And this is a checklist of people and places to call upon the death of a family member and an estate administration overview. So it's a good handy dandy guide to kind of refer with you and help you in your practices. So everybody ready to remember there are three things in 6 months' time? Yes? Good. Okay. So let us begin. So let's first start off with the foundation of the introduction and the concept of the role of a fiduciary. Now, if you look at the role of fiduciary and look it up in the Black's Law Dictionary, it defines a fiduciary as a person having duty created by his undertaking to act primarily for another's benefit in matters connected with such undertaking. Now, being named as a fiduciary is a job of which there is compensation, which is commission, and it all depends. I know there's a lot of online viewers out there from different states, so you have to look at your own particular state to see how the compensation for the fiduciary is determined. And there is a lot of responsibility, which is personal liability. And I once, it was once said, I heard it in another lecture, which I thought it kind of captures it really well, is like, being a fiduciary is not an honor, it's a job. And perhaps at the end of our program this evening, if Uncle Joe asks you to be the executor of his will or a trustee of a trust, you will make that decision in a more informed manner, and maybe for some of you, you may say, thanks, but no thanks. And can you expand a little bit about what it means to be named as a fiduciary and responsibilities and liabilities?
Right, sure. Fiduciary's obligations emanate from two primary sources. One is the terms of the governing instrument, whether it be a will or a trust, and the other is the law. Jill suggested that the appointment is not an honorary one. What that really means is you don't have an option not to act once you're appointed. And that's true even if you have a co-fiduciary. So, if you and your brother are appointed as co-fiduciaries of your mother's will, and your brother does all the work, and you stand by, at the end of the day, when your brother's gone wrong, there is no defense, I was the passive fiduciary. He did all the work. You have an equal obligation with your co-fiduciary to administer the estate. You have equal liability. So that if your poor third sibling, who was not appointed as a fiduciary, points a finger at you, you will be held equally liable with your errant brother. By liability, it's personal liability. That means the money may come out of your pocket, may come out of your compensation at the end of the day. It could even be liability in excess of the compensation you would have received for acting.
Thank you. Now, I'm going to be referring to some parts of New York law. I know there's a lot of you out there that are not New York lawyers, but so again, my reference is just a kind of a sample. You need to check your own particular states. And a lot of these states are very similar. So a lot of the concepts that we'll be going over will also translate into your particular state. But I urge each and every one of you out there in TV land to take a look at your own particular state statute on this. So a fiduciary is defined in the New York County Surrogates Procedure Act. That's our book here.
It's our Bible.
Our Bible. And it's called the Green Book because it is green. Section 103, 21 in the whole, it defines our fiduciary as, and it's a whole laundry list, but I'm just going to kind of highlight some of the more important ones because it kind of goes on, and we do have a limited time for the program. So an administrator CTA, an administrator DBN, an ancillary administrator CTA, our guardian, our executor, our preliminary executor, our temporary administrator, our testamentary trustee, and to any of whom letters have been issued. There is a few more, but again, that's kind of just the main folks. Now, when one becomes a fiduciary, their relationship before that time is transformed. The representative must discharge their duties with care and skill and prudence and without conflicts of interest, which may deter her from advocating the interests of the persons for whom she is a fiduciary. The representative must always bear in mind that each action he takes will be assessed strictly in relation to its impact on the persons for whom he serves as a fiduciary. And can you share some practical advice that when you first meet a new fiduciary on kind of general good practices, so when people out there know what they're getting themselves into? Or for clients, you know to advise a client if someone calls you up, I've been named as an executor or trustee. What does that mean?
The first order of business when you have been named and decided to act as a fiduciary is to familiarize yourself with the terms of the governing instrument, whether that's a will or an inter vivos trust agreement. You need to know what the instrument tells you to do. The second order of business is to figure out what the law requires of you, both complementing the provisions of the instrument and contravening the provisions of the instrument. So, if you're a lawyer and you meet with a client, you're going to review the will, but you're also going to say, P.S., there are certain provisions in this instrument that are absolutely unenforceable under the law, and from which you can take no comfort.
Give us an example of that?
I'm going to, yep. One example, which we see all the time in instruments, is what we call an exoneration clause. It says, no matter what you do, fiduciary, don't worry, you will not be held liable for it. If you commit acts of negligence, if you fail to properly administer the estate, no one can come after you. That's not true. The law has anticipated that testators might provide you with that kind of cover, and it said, nuh-uh, as a matter of public policy, you will be held liable regardless of the terms of the instrument. That means when you go through the instrument with your lawyer, you're a fiduciary, you want to know, does this hold? Does this protect me? Another example is oftentimes instruments say, fiduciary, don't worry, you have no duty to diversify the assets. You want to keep them in the billion shares of Mobil or Exxon? Go right ahead. I always like that security. And you have no duty to spread the risk out and diversify? That's not true. In fact, a provision in a will that says no duty to diversify really means that you don't have a duty to sell the assets solely for diversification purposes. There may be a billion other reasons you have to sell the assets, such as they're losing value, such as that they are not good investments for the type of provisions you have in your trust agreement. They don't produce sufficient income, for example, for the primary beneficiary of the trust. So you need to separate out what is and is not binding on you as a fiduciary, what will and will not protect you as fiduciary, and for that, I modestly suggest, you really do need a lawyer. Clients also have to be made aware of their duties. Some of them are obvious, right? Well, obviously I need to collect the assets because I'm ultimately going to have to pay them out. I'm going to have to determine what the expenses are of the estate, of the decedent, that the estate is responsible for paying. I'm going to have to make distribution to the beneficiaries named in the instrument at the end of the day. All true. But there are, I'm sure once you look at Jill's checklist, it's going to be made totally obvious, but there are a ton of other responsibilities that go along with being a prudent fiduciary, and that will, and your recognition of what those are will keep you out of trouble and from having a claim at the end of the day that you breached your fiduciary duty, leading to your personal liability. If there is an outstanding lawsuit against the decedent, you're charged with defending it. If there are assets that need to be converted, if there are corporate actions that need to be taken, all of that falls on you. You step into the shoes of the decedent, and unlike the decedent who can do anything he wants with his assets, you have to administer them prudently. You have to engage advisors. You don't have to engage advisors. A prudent fiduciary will engage advisors. If you have securities, you will need an investment advisor, unless you've got this expertise yourself, you'll need an investment advisor to tell you what to liquidate, when to liquidate it, what it will be prudent to hold, an investment advisor. If you have tax obligations, which you invariably do, whether it's filing income tax returns on behalf of the estate or filing an estate tax return with the federal or New York taxing authorities, you'll want an accountant. You may want a broker to sell real property because you're not going to distribute that property in kind to the beneficiaries. You're going to liquidate it and distribute the proceeds of sale. So you'll need to engage appropriate advisors, and you'll need to determine that they are charging a reasonable fee, because if they're charging an unreasonable fee, guess what? Personal liability on you. Over the course of administration, you'll have to maintain careful records, and we'll go over what that means later on. But one of the most critical aspects of estate administration in terms of staying out of trouble is maintaining appropriate records so that you can demonstrate that you have been a prudent fiduciary. Equally important, and almost always missed by the lawyer explaining the duties to the fiduciary, is that the fiduciary's communications, whether they're with a co-fiduciary, an investment advisor, an accountant, their brother, may be ultimately reviewed by the beneficiaries in an adversarial context. I probably should sell that security because it's clearly a dog, but I'm not in the mood. That communication, sent in email form, is producible if there is ever litigation over your performance as a fiduciary. As a fiduciary, you shouldn't write a single thing down that you're not able to defend at a later date in a court of law when you're subject to the claims of an adversary, such as one of the beneficiaries of the estate.
Okay. So, just kind of going forward, and again, this course is a basic course, and while a fiduciary can mean many roles, I gave that whole long laundry list, and we don't have time to go into all those subcategories. This course is going to focus on the most common, so we're going to be breaking this program down into our executor administrator, which I'm going to kind of put them together as one, and because they're pretty much the same things for both of them. The only difference is, anybody remember? Our executor, they're executor of what? A will, yes, thank you. And the administrator is where there is no will, that's right. And when we're going through the probate process, we have to try to remember, I'm thinking of last will and testament, and the court issues letters testamentary. Testament, that's how I remembered it in law school. And in the administration, where there's no will, the administrator. So we have our executor, administrator, they're kind of doing the same thing. One is doing with the will, one is doing without the will, because there is none. No legal one that ultimately comes to being. And then we have the trustee. And we're going to talk about what each of these roles mean, the respective duties and the consequences for failing to adhere to those fiduciary principles. And I mentioned a little bit earlier about liability, and I'd like to just get a little bit more. Can you give us an overview of the different types of consequences for a fiduciary's failing to meet his or her duties? Like an overview. These are all the bad things that can happen. I know Halloween's over, but
It would be my pleasure. If a fiduciary fails to properly perform his or her obligations, the fiduciary can be removed from office before the estate or the trust is ever fully administered. Okay? Plucked from the job. Not every breach of duty, though, supports an application for removal. That's because courts give great deference to a testator selection of a fiduciary. Court's notion is, you picked him, we're loath to take him out. If a person who's seeking your removal as fiduciary establishes that your continuing to act poses an ongoing danger to the estate, you're out. Oftentimes, though, you commit a wrong as a fiduciary, and the beneficiary seeks your removal, and the court says, you know what? There's no ongoing danger to the estate. We will resolve the consequences of your bad act at the end of the estate administration in what we call an accounting, where you're called to account for every single transaction you have undertaken during the course of your duties. Okay? And at the accounting stage, if you're still in office having committed a wrong, the court is going to determine the damages that you have caused. Okay? You may commit a wrong and there may be no damages. Great for you. If you commit a wrong and there are damages involved, then, as I said earlier, you will bear personal responsibility, dollars out of your own pocket, to make the estate or the trust whole. Okay. Example. You negligently retain a stock during the course of the estate's administration or the trust administration that a prudent investor would have sold. That is established to the court's satisfaction, typically through expert testimony, because the court's really not in a position to judge whether a stock should be sold or retained. Okay. So the expert convinces the court that the stock should have been sold. If you're a trustee, the amount of damages you're going to have to pay will be this. The difference between the value of the stock on the date it should have been sold and the value of the stock on the date you sold it, if you did in fact sell it, albeit late, or the value of the stock at the time of the accounting, if you're still holding on to it. okay? Many banks have been surcharged in the millions of dollars for holding on to stocks that should have been dumped far earlier. Okay. The figure, the damage calculation, the difference between the price when it should have been sold and was sold, will be offset by potential capital gains, right? Because if you sold it and there were any capital gains, it would have reduced your net proceeds, right? It is also possible that a court will award interest on top of the damage award. There'll be interest running. Of course, that interest is going to be offset by any income or dividends that were generated while you were foolishly holding onto the stock. Okay? Finally, the court can deny or reduce your commissions. Typically, if there's a damage award and you're entitled to commissions, that's the first line of attack. Your commissions are reduced by the amount of the award that the court makes to the estate.
Thank you. So now let's kind of move on to our executor administrator and talk a little bit about the property that they're responsible for. So let's kind of like start from like the 10,000 viewpoint. A 10,000-foot viewpoint. So our executor and administrator, they're responsible for a certain type of property, and that's probate property. Nowadays, there are basically two ways to pass property at your death. One is through your will, or if you die without a will, you have your administration, or the other is through a will substitute. And will substitutes are all around us. What a will substitute is, it's an asset that passes by operation of law to a joint owner or a named beneficiary. And the fiduciary is only when I'm talking about fiduciary here, I'm thinking about our executor/administrator. They're only responsible for probate property. And that property is property that the decedent had in their sole name with no beneficiary, no joint owner. So there's lots of will substitutes out there. And in fact, there are many people that actually pass a substantial part, and in some cases, most of their assets through will substitutes. So, again, a will substitute is an asset that passes by operation of law to a joint owner or a named beneficiary. Now, everybody's here as a lawyer. Can you guys think of, they're all around us, they're in your work, you see them on TV. Give me some names of some good old-fashioned will substitutes. Insurance. And insurance is, names a beneficiary. Now, I know this is not my law school class, but I'm going to put some people on the spot here. And is there a way to take that classic will substitute with a named beneficiary and convert that into a probate property? What could possibly happen? Anybody can think about it? Naming the estate as the beneficiary as one. Anybody want to think of something else? How about the person we name predeceases and it lapses? Okay. All right. So here we have our life insurance. Other will substitute out there. Pension, retirement accounts, huge part of our typical estates. IRAs, 401ks, profit sharing plan, beneficiary designations passed by operation of law. Okay, what else? We've been talking about investing here. Anybody have some idea? Pardon?
Real estate.
Real estate, yes. We can have real estate that is joint tenants of rights of survivorship. Let's talk about going back to Law School 101 and real property. How about property held by husband and wife is called? Tenancy by the entirety, that's right. So we have joint tenants of rights of survivorship, and that can also go for not just real estate, but what else? Our brokerage accounts, right? You see it right on the statement, JTWROS, joint tenants of rights of survivorship. What else for our investments? Anybody?
Trust.
Yes, ITF, in trust for, or TOD, transfer on death, or POD, payable on death. These are all our will substitutes. And those assets pass by operation of law to our named beneficiary joint owner. And that is not responsible, not in the hands of the fiduciary. Right, Ann?
That's correct.
So what happens, I'm gonna throw in an extra question here. What happens if I have, and this is like, I always like to sprinkle things with real life stories. We have we have little bank accounts, ITF for the grandchildren, and we got to get it, and it passes them by operation of law. And I have the mother calling me up and saying, because I represent the executor of the will, oh, I want some help doing that. come on, be a good sport and help me out, you know, so-and-so's lawyer helped them out. What am I going to say? Can I do that?
Can you help them?
Well, charge the estates for it. Because does the assets passed by operation of law, which doesn't come into the hands of my fiduciary. My fiduciary responsible for that?
Nope.
No way. I can be if I want to help them out of my own personal time, that's fine, but my fiduciary is not responsible for that. So what I tell them is like, okay, I'll be very helpful and I'll give you the death certificate, but it is your responsibility and you can collect it. I don't mean to be difficult, but it is not the fiduciary's responsibility, and I can't charge legal fees for property that doesn't pass through my hands, right? So that's our difference between our, will and will substitute. So understand, future fiduciaries out there, that you don't want to be getting involved with that, and you are responsible. The stuff that passes in your hands are probate property. So when we're doing our administration of the estate, one of our first steps that I always do is we do our inventory of assets, okay? And we see what assets are the responsibility of my fiduciary with no joint owner or named beneficiary, or none of those are failed that falls within would become probate property. And those assets that have our joint owner or named beneficiary, and then we just kind of facilitate, here's the death certificate, here's the information, but you know what I still need to know, and we can talk about that later? I need to know, I'm not completely off the hook for that information. I need to prepare one very important thing. Can anybody think about what that may be? Our estate tax return, that's right, and our final income tax return. I can't just say, oh, it's not my problem and you go collect it. I'm still responsible for that. So we want to say it's not responsible for some ways, but I still need to know that information to have it properly accounted for. So we have our will substitutes. Now, and again, our probate property, that is in the jurisdiction of the court, our probate court, but a very common area of controversy is here our decedent dies, and an asset, and whether an asset was given away by the decedent before death, okay? So our decedent dies, we have our probate property, but then there's some beneficiaries that complain, hey, I don't think that asset should really be in the estate. I don't know if it was gifted or not. And can you give us some examples of where there's a dispute if a gifted asset is in decedent's estate? And can you tell me what some of the factors that the courts look at in making this determination? And then, in your experience, how do you see these disputes settled generally, these issues?
Sure. It's a common dispute, actually. And the closer in time to death that the purported gift is made, the more likely we're going to have a dispute about whether the decedent had capacity to make it, was unduly influenced to make it, or even a dispute about whether delivery occurred prior to death. If an executor thinks that a gift is invalid and should in fact be part of the decedent's estate, there is a particular proceeding to be brought in surrogate's court. It's under SCPA 2103. It's referred to as a turnover proceeding, as in turn over the asset to me, the executor. If the executor isn't sure, and Jill made reference to this, I don't know if it should be part of the estate or not. There is a proceeding also under 2103 called an inquiry, where you get to haul the donee in and depose him under oath as to the circumstances under which the purported transfer was made. If you're the donee in those circumstances, life sucks for you, because the burden is on the donee to establish by clear and convincing evidence 3 prongs of a gift. Now, these are 3 prongs that apply to all gift transactions, right? An intent to make a gift, delivery of the gift, and acceptance of the gift. Acceptance is implied for obvious reasons. Okay, intent comes up a lot. You tricked mommy into creating a payable on death account, right? You tricked mommy into changing the beneficiary designation, okay? The donee has to show that the gift was knowingly and voluntarily made. Okay, but here's the rub. Proof. The donee doesn't get to say, it was a gift, mommy intended to give this to me. We had a conversation right before we went to the bank. The donee does not get to talk about any conversations he or she had with Molly. Under CPLO 4519, the dead man statute, you may not testify as to communications you had with the decedent. Anything the decedent, if alive, could contradict or explain is off the table. So there goes your mommy told me proof, okay? What's left? Documents. And how often are those transactions the subject of written communications by the decedent? And third parties. Third-party disinterested witnesses. The combination of the proof problem created by 4519 and the very heavy burden faced by the donee in terms of clear and convincing evidence makes for a lot of case law in which the gifts fail, or a lot of settlements in which there is some sharing of proceeds between the estate and the purported donee. One last point. If the gift is made to the donee, by the donee, using a power of attorney, good luck. It's even harder to have a successful defense of that gift. For one thing, the donee has to establish that it was in the donor's best interests to make that gift. And how often can one say it's in the donor's best interest to give money away? It usually is the donee's interest, right? That's the whole point. So you'd have to show something like the donor had a long history of gifts to his or her kids, and it was an overall wealth transfer plan, and this was just one step in a larger plan. Then you might have a chance. Otherwise, if you're making gifts to yourself under a power of attorney, even where you have a power of attorney document that allows those gifts, it's a tough road.
All right, great, thank you. I'd just like to point out for all of the folks in webcast land that, as Ann mentioned, certain sections of New York law, please go and check your own particular state statutes. Even though there are New York citations and New York bases, most of the states out there probably have very similar statutes. So go and check your own statutes, please. So let's kind of move along and continue to talk about our executor and administrator as a fiduciary. And again, we're going to be talking to them again as one bundle because many of these same considerations also apply, and also some of these considerations apply to the trustee as well. So just because we're going through some of these, there is going to be a lot of overlap as well. So let's talk about the executor. And now the Black's Law Dictionary defines the executor as a person appointed by a testator to carry out the directions in his will and to dispose the property according to his testamentary provisions after his decease. The Uniform Probate Code includes the executor as a personal representative of the estate. So I know, out there again with different states, some states like to call our executor a personal representative. Some people call it executor. Again, you got to check your own state statutes. So, and now comparing that to our administrator, that is the person that is appointed by the probate court to administer or take charge of the assets and liabilities of a decedent. Now, there's generally an order of priority on who can serve based upon who are the main beneficiaries of the decedent's estate. And if you think about it, doesn't that make sense? Here the person died, there's not a valid will, person dies without a valid will, or didn't do a will at all. And so who are the people that most likely should make sense to be in charge? Those people that have the greatest interest, right? So for New York, our Surrogates Court Procedure Act, Section 1001, sets forth our order of priority to serve, and it basically tracks our intestate distribution of a decedent's estate, and the intestate distribution statute is Section 4-1.1 of the New York Estates, Powers, and Trust Law, as we love to refer to as the EPTL. Sometimes, and when you're looking at the different levels, okay, on who, the priorities on who can serve, there could be multiple people in that same class. So you could have multiple persons at the same priority, children, parents, siblings, And therefore, I believe it's best, for all parties involved. So if you have multiple people, like the siblings are going to be the ones that are going to be serving. We have 5 siblings. Let's have the conversation. Who's going to be the one that's appointed, or people plural, and let's do this before we get the papers together, if we possibly can, so we avoid any potential conflicts in advance. Again, I'm a big believer, let's try to resolve it beforehand. But that doesn't always work. And sometimes, you may have people don't get along in your family, right? You can pick your friends, but you can't pick your relatives, right? And so you may have, maybe several children, and they each, we have maybe 5, and one person wants but doesn't want the other, and that person wants but doesn't want the other. So, Anne, can you provide some insights of, when we have multiple people in the same class applying for our letters of administration, how these conflicts are typically settled?
Yep. Let's just clarify the scenario. Multiple people in the same class. So, New York, spouse has priority. If the surviving spouse dies, leaving 5 children, and 2 of those kids want to serve, and they each file an application saying, pick me, to the court. The court will usually first inquire whether they can serve together. Wouldn't that be nice, the court says, when faced with those competing applications? When the answer comes back, as it typically does, no, then the court looks to who's got the vote, okay? It looks to the majority of class members and says, who do you want as a class? Oh, 5 kids. We got 4 kids, 1 petitioner, and 3 kids supporting that petitioner against 1. Guess who's going to get the letters, right? The court recognizes that majority should control. And as a result, if you're the practitioner, before the application is even filed, when you know that there's going to be a competing application, okay, you're lining up, right? You're calling. You want to support me? You want to file a consent on my behalf? You're looking to get those members in writing in the form of a consent on your side of the aisle so that you can convince the court that your sibling's application ought to be denied and yours ought to be granted.
Great, thank you. So now we have our executor, we've got our letters testamentary if there's a will, or letters of administration, and now we are going to start doing our thing. So our executor/administrator is primarily charged with collecting and liquidating the estate assets as soon as practical. Our executive administrator will turn the assets into cash where necessary. They will pay the funeral expenses, debts, taxes, administration expenses, and then afterwards, they'll distribute the remaining assets in accordance with the terms of our will or the laws of intestacy where applicable. Or if we have a dispute, they will distribute in accordance with the settlement that was done. Our executive administrator also has a responsibility to prepare and file our decedent's final income tax returns, our estate tax returns, and our estate's income tax returns. Let's just kind of take a pause in the moment because sometimes people get confused on that. So our final income tax returns, that's going to be our final 1040. And you should get your proper advisor to help you with that, unless, of course, our fiduciary knows how to do that themselves, or probably says CPA. Our estate tax returns. Now, a lot of people get all excited because our federal estate tax exemption is $5,250,000 and say, I don't need to worry about an estate tax return. We also have portability, so it's $10,500,000. I don't have to worry about federal estate taxes. Wait a minute. There are estate taxes on the state level too. So for New York, our threshold is $1 million. And for New Jersey folks out there, like me, $675,000 I heard in the audience. So you have to check your state rules on that. Don't get too excited about the federal rules. I mean, that's a good thing, but you have your state as well, your state estate tax liability. Now, you also have your estate income tax return. So the decedent dies, and that's our date. But they've held lots of assets, bank accounts, brokerage accounts, and those assets are working for us, maybe real estate, and that's earning income. Just because the person died doesn't mean you don't have to pay the income tax on it anymore. So we have our 1040 for our individual, and we have our 1041 for our estate or trust. So you're going to have an accountant do the 1041, and that'll be your date of death. From that point forward, all those 1099s are going to be properly allocable to our estate. Now, this goes beyond the scope of this course, but there are certain elections and tax planning that can be done here. So you really want to find an accountant that really knows how to do your 1041, your decedent's the decedent's estate income tax return. And the way I always work with folks is that I always generally like to work with the accountant that the decedent had, because they're the most familiar with their history and have their records. But I want to make sure that they know how to do a 1041, not like, oh yeah, no, I've done that, like, here and there. No, you really want to know, you really want to work with someone that really knows that, because you can really add value to the client to minimize the overall tax picture. So you're going to be doing our estate tax returns. Now, let's quickly turn to one of our handouts, because we have a lot of responsibilities in the beginning. And this is now our checklist of people and persons to call upon the death of a family member, and our estate administration overview for our 10,000-foot view. Now, I'm not going to kind of read through the handout, but it is broken down into several sections. So people and places to call on the death of a family member within a few hours. So what would you probably want to do? You'd let the immediate family know. If you have minor children, the guardian know. How about the decedent's pets, the caretaker? If we have a person that was living alone and had pets in their home, we don't want to have that home with nobody in it. We got to take care of our pets. The executor of the decedent's will, so they know that they've got to meet with their lawyer and go over the terms, right? And our funeral home to organize the funeral, okay? If you have a business associates for the decedent, let them know too. Now, other folks for within a few days or a week, some of the things you may want to think about doing: credit card companies. Go get your decedent's wallet, go in their home. You got to cut those cards and cancel them, okay? I'm hearing more and more stories about fraud. I mean, we're hearing them, okay? You got to be very careful about that. Life insurance companies. Let's request our claim forms so we can get our money. I love life insurance money. It is our no-brainer money. It's paid very quickly, because when my new fiduciary comes in and I'm preparing my executor's cash budget, which is letting me know what my cash requirements are, it's kind of like that scene from Trading Places, at the end where they're going to be selling, sell. You remember that? Anybody remember that scene? Anyway, that's what we're thinking about. We have cash, we got to raise it. Our taxes are due within 9 months of date of death. You got to pay our lawyers, we got to pay our accountants, we got to pay some filing fee. We have investment advisors, we're going to need cash. We have general bequests we're going to need. We're going to want to know how much cash we're going to have, and we're going to want to raise that. So we want to get our life insurance money in the door. Social Security office, our insurance brokers, our financial advisors, and you're going to want to call your lawyer that's experienced in probate if you're the nominated executor. So you can make your appointment with the lawyer, so you can get to know what you need to do, and you can get on it. Okay. Also, you want to make sure, especially we're going into the winter months now, you want to make sure your home is safe and secure. You got to preserve the assets. So especially if the home, this is a real common thing. The person had a home, say, out on Long Island or upstate New York, okay, and it's now no one's living there anymore. You got to call your insurance company. Vacant homes, the insurance premiums are more than homes with people in it. Why? The squirrels can go in your attic. That happened to me last year. And I kept hearing the scratching. You got to make sure that doesn't happen. You got to make sure all the faucets are turned off so we don't have water. You got to make sure the heat is on so the pipes don't freeze. So, you got to be having someone go by and check the house. You got to call the insurance company so they update the information that this is a vacant home. Because if something happens and you don't do it,
liability.
We don't want that. And then within the first month, maybe the following context. You want to go speak to the utility companies, got to update that information. Also, one of the first important things, you got to forward the decedent's mail. Your mail is your big set of clues. As I always tell people, like being an executor or administrator, it's like being Sherlock Holmes. I sometimes think one of these days I got to get a Sherlock Holmes hat, put it in my office, so I can really show people that you really got to investigate and find things out. And you find out some really interesting things about the family. You really do. And there's always some surprises. Sometimes good, sometimes bad, but you are looking and finding things out. Department of Motor Vehicles, you want to let them know. You're going to be canceling your subscriptions. Again, speak to also the decedent's accountant to take a temperature reading and filing the final income tax returns, or if they're going to be doing the 1041. And then an overview of your general estate administration process as fiduciary to kind of get to know the life cycle of our estate. So we're going to have, and I always tell folks, in the life cycle of an estate, it's somewhere between, if it's a taxable estate, somewhere between 2.5 and 3 years, okay? And there's periods of activity and there's periods of inactivity. So our periods of activity, right when the person dies, you're going to be probating the will, you're going to be collecting your assets, valuing your assets, you're going to, identify them. That's where your Sherlock Holmes comes into play. You're going to be looking at your final income tax returns, or the last 3 years is what I like to look at, because what's going to be on our income tax returns, our decedent's income tax returns? Clues of asset trails, 1099s, interest, dividends. Look on the Schedule D for capital gains transactions, K1s, any interest in trusts or closely held businesses. You're going to need to deal with those assets. Our income tax returns are filled with clues. And our mail, every month the mail comes, also you open it up, filled with clues. Preserve our assets. That's another part of our estate administration. Discontinue any unneeded utilities. Let's face it, after the decedent's gone, we don't need that subscription of Netflix anymore, right? We don't need the health club membership of $150 a month. These things may be small little things, but we don't want to have these things out there that this is part of a whole pattern of neglect, right? We're going to be inventorying our assets. We're going to be doing our estate tax return, paying our debts and liabilities of the estate, and then at the very end, and this is where a lot of controversy comes in, we're going to do our accounting and distribution of assets. So that's our general life cycle of the estate. So again, there's periods of activity, periods of inactivity in the beginning, all of our collecting, valuing, appraising. We're going to be filing the final income tax returns, filing the estate tax returns. Obviously, if there's disputes among parties, all bets are off, and things can go on for a very, very long time. So that's our handout there. And going back to the tax returns, can you give us some guidance on this? We have our new executive administrator. We're going to be filing the decedent's final income tax returns. What is our executive administrator's responsibility? Should they be looking at or confirming prior years? Do they have the duty to audit to make sure it was done okay? What is their, give us some insights on our income tax return responsibility.
I don't recommend looking for problems. On the other hand, what if you find out that the decedent hadn't been filing at all? It's more common than you think. There's no easy answer in that scenario. I don't know what your practice is, but the argument can be made that you are required to correct that to the extent you have information that would allow you to file. There's no running of the statute of limitations on that problem, because you've made no disclosure to the IRS. So you don't have the typical 3-year statute of limitations. It's an open-ended liability of the estate. So if you have information going back 3 years, an argument can be made that you're required to make those filings. Certainly if there's an audit of a prior year, it is your responsibility as fiduciary to defend the audit and to involve the accountant in meeting with the IRS and dealing with any issues that arise in the context of that audit. Turning just for a second to the uninteresting topic of creditors' claims. One of the things you really have to be concerned about is the priority among various creditors. okay? Not all creditors are created equal. And you don't have the ability as a fiduciary to say, you know what, I really think I want to pay the mortgage, but I am not so interested in paying off this promissory note. Okay? If you pay some creditors over others and there's no money left to pay the other creditors, personal liability. Okay? So you need to identify your entire universe of creditors' claims and liabilities before you start distributing money to the beneficiaries. And when you line up all of those creditors' claims, you need to check your state statute. In New York, it's SCPA 1811, to see who's first in line and who's second in line and who's going to have to take a back seat. This becomes particularly critical when you have a potentially insolvent estate, because if you make a mistake, liability will result. And just one thought on distribution, because I know we've gone right through to distribution here, and that is distribution in kind. The state statutes typically allow you, as a fiduciary, to decide whether to distribute in cash or in kind, especially to the residuary benefit. Let me back up. Of course, the will oftentimes provides, Jenny's going to get all my jewelry. Then you're obligated to take the jewelry and turn it over to Jenny. But when the will says, and all the balance of my estate amongst my 3 children, as a fiduciary, by statute, you have the ability to distribute in cash and kind, or in kind. Can you sell assets over the objection of beneficiaries? Beneficiary 1 says, I want those stocks distributed to me. I do not want them sold. Beneficiary 2 says, sell the stocks, I want the cash. What is your obligation as a fiduciary? It is in your discretion to sell or to distribute in kind, except if the beneficiaries are unanimous and they all say, we want the stock in kind. Then, assuming you don't need that stock to satisfy the expenses of the estate, you have an obligation, at least in New York, to make the distribution in kind. That is the one exception to the general rule that the fiduciary is the fiduciary's election as to how assets are distributed.
Thank you. So let's kind of move along here. So let's talk a little bit about investing for a moment. So our executor and our administrator may invest estate funds even though they hold the assets for only the period of time needed to collect all of them, liquidate the assets, value them, file the appropriate tax returns, pay the debts, and distribute the remainder. So they may invest those. Also very interesting, there actually may not be a duty to probate a decedent's will if there is no probate property. Remember, going back to the earlier part of our program, that there are folks out there that may have all of their assets held in will substitute. So there are many estates out there that may have 3 main assets: life insurance policy payable to a named beneficiary. Say they have a home, tenancy by the entirety between husband and wife, and they also have a retirement account naming their spouse as the beneficiary, and then we have a will that said by the husband dies. It's one of my favorite vaudeville jokes. Why do husbands die first? Because they want to. That wasn't part of the outline, just threw that in. But anyway, so do we have to probate the decedent's will when our spouse already is getting everything by operation of law? And I don't think so, because unless there's some other reason that someone is asking for an executor, but there's nothing for the probate court to act on. So there may not be a duty. Our executor administrator is authorized to pay reasonable, proper administration expenses from the estate and the trust, including reasonable attorney's fees. Payment of administration expenses has priority over all charges against the estate, including funeral expenses and preferred debts such as unpaid taxes. This starts, when I'm talking about estate administration expenses, one of the favorite parts of estate administration expenses are professional fees, lawyers' fees, accountants' fees, and one of the big, it is an area of controversy at times. And can you, in our fiduciary, as Ann had mentioned before, you should hire proper advisors and counsel so they can properly advise you and guide you and follow the proper returns. Ann, can you expand a little bit on our fiduciary's right to hire counsel of choice, or are there any practical limitations? And also, do you need the consent of your co-fiduciary or the beneficiaries for you as executor or administrator to hire counsel of your choice?
Well, I'm happy to report that each fiduciary is entitled to hire counsel of his or her choosing. And even better, the fiduciary can pay counsel fees without his co-fiduciary or the beneficiary's permission. The payment of counsel fees, at least in New York, is considered to be what we call a unilateral right, meaning you do not need the fiduciaries to agree to the payment. But there is only, at the end of the day, one reasonable legal fee payable from an estate. So if I have two fiduciaries and those two fiduciaries want to hire separate counsel, great. But the separate counsel have to realize that they're not each getting a fee representing what it would cost to administer the entire estate. They need to coordinate so that there's no overlap with respect to the counsel's services. Otherwise, both counsel will be cut back by the court, and you each will be made to look to their own clients to make up the difference, if that's what the retainer letter says, which it ought.
That's one of the three things you should remember.
A direction by a testator in a will to hire a particular lawyer. You fiduciary go out and hire lawyer X when I die. I want that lawyer to administer my estate. Is unenforceable under New York law. Fiduciary always has a right to select his or her own counsel. One caveat, if the fiduciary hires his or her own law firm, so that the fiduciary is acting to administer the estate, and the law firm is providing legal advice. In that event, the fiduciary can't simply pay the law firm as the bills roll in every month. Instead, the fiduciary has two choices. One, make an application to the court for an interim fee award. Court, can I pay my firm? We're 6 months into the administration. Bills have mounted. We want to get paid now. And the court can allow that or not. The other is getting the consent of the parties to an interim payment. If you have consent of all parties, you can do it that way. Otherwise, you have to wait to the conclusion of the estate administration to pay your firm's legal fees.
So now let's move along to areas of risk for executors and administrators. Now, there are obligations that incur prior to our official appointment or the granting of letters. So our nominated fiduciary for our executor, they can pay reasonable funeral expenses, collect assets, but they do not have the duty to, but they do have the duty to take measures to preserve the estate. So there was a case in Ray Donner, the New York surrogate surcharged our co-executors and limited their commissions for losses sustained by the estate before letters testamentary had issued to them. And can you provide some, explanation as to what an executor administrator must do to avoid trouble here before they're officially appointed?
Sure. It's never a good idea to delay offering the will for probate and getting letters. If you anticipate that there's going to be a delay, and there's any number of reasons there could be a delay, locating beneficiaries, locating persons who have to be cited in the proceeding. Sometimes kids have gone missing and you have to publish in newspapers to give them notice that a will is being offered for probate. Sometimes the will is subject to challenge and it can't be admitted to probate and you can't get your permanent letters for a while. In that event, it behooves you to seek what we call preliminary letters. And those preliminary letters, once granted, will allow you as fiduciary to do everything you could do as a permanent executor of the estate, but one thing. You cannot distribute the assets until you've been permanently appointed. So you can pay all your bills and collect all your assets and preserve the estate, sell assets that are declining in value or that you're concerned may decline in value. If you fail to do that, if you fail to timely get authority to administer the estate, as the Donner case shows, it is possible that you will, once appointed, be held liable. That means as a fiduciary, if you have someone come through the door and they say, you know what, here's Mom's will, it's been in the closet for 5 years, I don't know, maybe we ought to sell the house now. I have actually said, you may want to think twice. Has there been a decline in value in any of the assets? You may want to think twice before stepping up to the plate and offering that will and getting and qualifying as a fiduciary under it. Because you certainly don't want to be smacked on the back end with a claim that you have failed to protect the assets of the estate. The flip side is, as an administrator, as a volunteer where you're not appointed under an instrument, there's been no case that has suggested that if you come in 3 years later and there is no will and you say, you know, I'm the sole surviving kid or I'm one of 2 kids and I want to administer the estate, that the court would take the same action against you as an administrator. There's no case that suggests that, and I quite frankly doubt that it would come down that way. But so be careful about delay.
Thanks. So now we know, kind of moving right along here, we have our we've gotten appointed, okay, and we're taking care of business. So we're going to be collecting assets. That's one of our first order of business. Our executive administrator must collect assets, and if estate property is withheld, must try to recover property or the proceeds of value. So what does asset collection kind of mean? Some practice. So what that basically means is that we're going to identify the assets. Remember, the mail, the income tax returns, the brokerage accounts, the bank accounts, the real estate. So I'm going to say, for the example of a bank account or brokerage account, I'm going to get our statement. I'm going to look at the person's name there and a phone number to contact them if there's a financial advisor or a banker on there. I'm going to call them up. I'm going to find out the laundry list of items that they need to collect it, and then I'll put the package together and collect it. Very common. They may want to have a letter that says medallion guaranteed. They may want a W-9. They might want a copy of letters testamentary. They may want an original. They may want a death certificate. These are typical items that they may request. I think it's always good ahead of time to kind of know what our world of requests are, because it is not uncommon that you ask the person on the phone and they're like, oh yeah, we'll take these 3 things, and they don't ask for letters testamentary, and then you send them the 3 things that the person said, and then you're waiting and waiting and waiting for your check to come, and it doesn't come, and you call back, oh, I'm sorry, I forgot. This is my first week on the job, and you actually need, letters testamentary also. Also important, ask if they want an original or an original certified with a raised seal, or will a photocopy too be okay. Especially with our letters testamentary and our death certificates, there are costs involved with that. So frequently what I'll do is if they want the original, I'll put in my little package, hey, here's a self-addressed stamped envelope. When you're done with that, can you kind of make the copy in your office so you've seen it and touch the little raised seal, and then get it back to us. Because death certificates are like $10 to $15, letters testamentary are $6. It adds up. It's being smart, and doing that. So that's our asset collection process. Now, also, our executive administrator has a duty to invest the funds and that are not required for the payment of claims and expenses unless funds are needed to be distributed within a short period of time. For example, the failure to invest cash funds in an interest-bearing account was cause for surcharge. In the last 5 minutes before we take our break, Ann, can you give us some guidelines on an executive administrator on the investment of estate assets and the liquidation of investments to preserve values, like maybe rolling T-bills or money market accounts? Can you give me some guidance?
Sure. As Jill suggested, you need to raise your cash requirements. That's the funds that you need to pay debts, administration expenses, and cash bequests as quickly as possible. Cash requirements are fixed expenses. They're not going to diminish. You're always going to have to pay the debt, pay the bequest, satisfy the administration expense. But assets fluctuate in value, right? So if you are holding assets and not selling them to raise cash requirements, and the value goes down, that means you're going to need more of those assets to satisfy the same fixed pot of expenses. Raise your cash requirements as soon as you possibly can. Don't look to time the market on that. Okay. As Jill suggested, they have to be invested in interest-bearing accounts. The court will surcharge you, will hold you liable if you simply put that money in a drawer or in an account that does not bear interest. Even if you are forced to put them in the very low interest vehicles that exist today, you have to make sure that you put it in typically government obligations, treasuries, money market accounts. What you're looking for is a safe investment that pays the highest yield you can get. Okay. The best practice is to consult your investment advisor about the vehicles that provide short-term liquidity with the highest yield and the lowest risk, right? Investment advisor, I need to raise $10 million to pay my short-term expenses. Here's my pot. What do you suggest that I get rid of, that I sell, in order to make my nut, okay? Since all the cash is not required at the same time, you need to indicate to the investment advisor what you need when. What's the timeline? A prudent fiduciary is going to differentiate between amounts needed today and amounts needed, for example, 9 months from now when they pay their estate taxes, and amounts needed on a promissory note that doesn't come due for 2 years. You want to tell them what you need now, and you want to allow them to plan for what you'll need in the future.
Okay, great. Now, where the executive administrator invests the estate's funds, the needs to monitor, you still need to monitor our investment advisor. So you get your investment advisor, it's not like, okay, I'm fine. Now, this generally is much more important for the duty for a trustee than our executor, which we'll be explaining later. Generally speaking, our investment strategies are different for executive administrator than for a trustee. Our executor is under the duty to seek out, collect, preserve the decedent's assets, and distribute the remaining assets after the payment of debts, taxes, funeral, and administration expenses. Our executive administrator must keep clear and accurate records of estate activity. This means keeping the receipts for the amounts paid, copies of invoices, bills, statements, and checks for all payments. So Ann, can you give us some guidance on best practices for record keeping, please?
Yep. Why is record keeping important? Failure to keep accurate and complete records is a breach of fiduciary duty, which can lead to, guess what? Liability. If records are not kept, then all presumptions are taken against the fiduciary. So, if a trustee has spent money on legitimate trust expenses, but hasn't kept the receipts and has no proof of the expenditures, at the time of the trustee's accounting, if I'm representing a trust beneficiary, I'm going to call for those receipts. He's going to be unable to produce them, and I'm going to argue, likely successfully, that he's entitled to no credit, despite the fact that he properly spent those monies on trust expenditures. In fact, I've succeeded in cases where there have been no receipts, just because I didn't keep them, in eliminating credit for the entire schedule of expenses. Hundreds of thousands of dollars expended by the trustee and no credit for that, which means they have to put hundreds of thousands of dollars back on the table. Okay? So that's why it's critical that you keep good records. Now, Jill mentioned monthly statements for all accounts. If you have a 20-year trust and you account in year 20, you should have monthly statements for the entire 20-year period. If you don't, and your counsel has to go to the bank and ask for those statements, guess what? Bank says 5 to 7 year retention policy. Big trouble. Jill mentioned all receipts. That includes all bills from your lawyers and your accountants and other professionals over the entire 20-year period you're accounting for. Keep all communications with your beneficiaries. All of them. Keep minutes showing the basis for your investment decisions and to prove that you have monitored the investments over time. So if, as a matter of prudence, I'm meeting with my co-trustee and my investment advisor 4 times a year to review the trust assets, I want minutes of each of those meetings. I want them in the file, so at year 20 when I'm accounting, I can show the basis for my investment decisions. I want to keep all the income tax returns for the trust or the estate. I want to keep all comparable sales and appraisals. If I'm sold real property in either a trust or an estate, I want appraisals for all property that I've disposed of over the course of an estate or a trust to show that I got a reasonable price for the asset and to thereby fight off objections to my actions as a fiduciary. Record keeping is one of the most critical aspects of trust or estate administration.
Okay. That is a good one of those 3 things to remember in 6 months' time, folks. Good record keeping. When in doubt, save it. Okay? So kind of moving along, our executor and administrator has the duty to keep estate funds separate in the name of the fiduciary and kept in a separate fiduciary account. No commingling, okay? You want to open up your own account in the name of our estate or in the name of our trust, okay? Real estate. Very, very common asset in the estate, and we're very often selling it, especially if it's the decedent's residence, okay? And the sale of real estate can be an area of potential conflict with either a co-fiduciary or the ultimate estate beneficiaries. So, for example, with co-fiduciaries, especially if they're executors, and they're also, some or most of the remaindermen. One person may think, well, I want to keep it. I think the market is going up. And the other person is like, I want to terminate the estate. I don't want to keep it for another 5 years. Disagreement about that. The terms of the sale, the listing price, or the beneficiaries, they can object to how the sale is handled when they eventually account. I don't like, you didn't get enough money. For it, you should have, maybe redid the apartment a little, painted it so it'd show better and get an extra amount of money. So you have that issue. Our executive administrator has the authority to sell the real estate that was not specifically devised, provided the governing instrument does not otherwise limit the power. And even if the property is specifically devised, there are some circumstances that we can nonetheless sell it, especially if those beneficiaries agree. Our executor and / administrator has wide discretion to determine the sales price and the sales terms, provided they are in the best interest in the estate. But going back to my first point in this topic, the sale of real estate is a hotbed for disputes. And to this end, and again, it's my experience that the selling the real estate as part of the administration of the estate is very common. And can you provide us some good practical suggestions on how to handle our sale to minimize objections and other complaints down the line?
Well, as with most other aspects of estate administration, process is all important. Hire a good broker. Be able to show that the property was marketed to draw the widest audience and the most offers. Do not, under any circumstances, be tempted to engage in a sweetheart deal. I can't tell you how many times I hear some variation of the decedent would have wanted me to sell it to X, the next door neighbor, right? Your job is to garner as many offers as you can, the best price that you can. You have to have a reasonable basis for the sales price, right? Typically, when you sell your house, you seek a broker's guidance on how to set the sales price. But you are free, if you're just a typical seller, to sell at any price. As a fiduciary, it's not enough to say to the broker, what do you think I should put it on the market for? Instead, you want to demand comparables. You need an appraisal. You need some objective basis to point to show the beneficiaries who may object that you obtained a good price for the property. If a beneficiary wants to purchase the property, be careful to ensure that he or she is paying fair market value, again, against an objective measure, such as an appraisal. The safest route you can take if a beneficiary wants to purchase the property is to seek the consent of the other beneficiaries after making disclosure about comparable sales prices and appraisals and any other information you may have that may affect the price to be paid by the beneficiary. If a fiduciary, happens all the time, if a fiduciary or a related party wants to buy the property, then what? I'm the executor, I'm thinking, why not me? In that event, he's got two choices. He can obtain written consents from each and every beneficiary who is impacted by that sale, or he can go to court, make his case to the judge that he is paying a fair, reasonable price for the property. Those are the choices.
Okay, thanks. In many estates, we have multiple fiduciaries. We could have co-administrators and co-executors, and they must work together to fulfill their fiduciary duties. Therefore, there must be effective communication between them. And with all people, when you get more than one person in charge, sometimes our co-fiduciaries may not get along. Okay. What should they do to minimize issues and objections in the accounting release phase? I mean, you had mentioned earlier, Ann, about counsel fees, and each person is entitled to their own counsel, but we want to make sure there's no overlap. So, when we have our situation where our co-fiduciaries don't always get along, what can we do to minimize the issues and potential objections down the line in the accounting release phase?
Majority rules decision-making, typically, unless the instrument provides otherwise, okay? That means if you have 3 executors or 3 trustees, 2 out of 3 get to determine the course of action that's going to be taken, right? There are exceptions to those rules, and we discussed one of them. You can each pay your own counsel fees without the other's permission, right? If you were the odd man out, okay, you're the third fiduciary that says, I don't think that's a good idea, folks, okay, and they overrule you. In New York, you must dissent in writing to protect yourself. Simply saying not a good idea offers no protection whatsoever, okay? And even a written dissent doesn't always save the day. Because if you stand by and say, I don't like it, I'm not voting for it, while your co-fiduciary actually causes damage to the estate, and you don't do anything to stop it, personal liability will be imposed. You have to take action to protect the estate. If you think your co-fiduciaries are doing something wrong, it is incumbent upon you to go to court and try to stop them. if there's a serious disagreement between fiduciaries, one mechanism that the law provides is a proceeding called advice and direction. Court, he says X, I say Y. Can you break the logjam? Courts will say no sometimes, because the court is never willing to merely substitute its own judgment for those of fiduciaries. But if one fiduciary is wrong as a matter of law, if the fiduciary's proposed course of action is a clear breach of fiduciary obligation, court will not hesitate to say so. So when I believe that a fiduciary is acting in bad faith or breaching duties imposed by law, I would not hesitate to bring an application on order to show cause seeking emergency relief to stop them in their tracks from acting. One more possibility is that the co-fiduciaries can seek the appointment of a third fiduciary to break the logjam. The court won't always go for it, but in appropriate circumstances, and especially if the logjam involves a limited issue, the court can put in a third person to whom each fiduciary makes their pitch, and again, majority rules, and that will solve the problem. Fighting fiduciaries are always fun, though.
Okay. So let's kind of continue on our areas of risk for executors and administrators. So our executors and administrators owe a duty to all beneficiaries to be fair and impartial in all transactions that affect them and cannot prefer one to the detriment of others or confer a benefit upon one at the expense of another. Okay. Generally, at the end of the administration of the estate, our executors/administrators are now ready to distribute the assets to the beneficiaries. They will account to the beneficiaries. Now, the accounting phase can take many forms, and this area is fraught with risk. Okay, so in New York, there's two general types. I mean, there's most of our states are settled what's called informally. Okay, and that's what's called with a receipt, release, and refunding agreement. And it's going to be something like along the lines like, okay, I have a general bequest of $10,000, and you're going to give. The person's going to acknowledge, yes, I received it. Yes, I'm going to release you, fiduciary, and then I will refund any money to you that if it's accidentally overpaid. And typically you can give cash sheets attached, which are our statements that Ann was talking about. You're going to be being good record keepers from now on, right? Or you can do the judicial road. Now, the judicial road is very expensive and time-consuming, and New York has their own way of doing things. They have a sort of so-called judicial format, and there's very complicated schedules, and you're going to need to hire a fiduciary accountant to prepare this. And this is not an inexpensive endeavor, and it is not something that doesn't take a short amount of time. Most of the estates get settled informally because the cost of this formal accounting proceeding, it's borne by the estate. So it's basically coming out of the residuary beneficiaries' pockets at the end of the day. So if everybody gets along and we can do things, settle this informally, then that is much better. One of the things to take into consideration, and I'm going to want Ann to expand on it a little bit in a moment, is the information that you're giving for your receipt and release. Certainly, if you give a receipt and release, and you say if you're a residuary beneficiary, because you're going to know what the residuary is, right? You got to start with what we've collected, what we've paid out, and what the residuary is. And if we don't have any information to determine how it is, maybe one or two statements, not enough information about the deductions, the distributions, maybe that release that you're getting maybe not be worth very much. Again, and the accounting can take many forms and has a lot of risk. Okay, that's for our fiduciaries. So you want to be very careful. Again, if you're doing everything along the lines properly in the beginning, then there shouldn't be anything to worry about down at the end when you account. Now, objections to our accounting can result in a surcharge against the fiduciary, which means personal liability. Some common objections include our professional fees are too high. Our assets were not promptly collected and lost value. Our assets were not invested properly. There are conflicts of interest. Maybe somebody, did a little self-serving, or preferred one person over the other, or possibly improper or poor tax planning. You had your cousin do the estate tax return, and you gotta, always want to do an estate tax return, and he learned it on your dime, and wow, we could have maybe gotten an estate tax return done properly and minimized the expenses and the estate tax liability. One of my favorite things I talk about in class is that there's two tax systems, one for the informed and one for the uninformed. And the ones that are informed always pay less. And in my opinion, an estate tax return is actually a legal document and not like a quote-unquote tax return. It is, in fact, for me, that is the only tax return that I prepare. And when you're doing it, it's actually an art. There are, you have an understanding of what the case law and the IRS positions are on certain on the valuation of assets, on the allowability of the deductions, and knowing those things, you can properly prepare it to minimize your risk of audit. Being aware of the top 10 lists that are estate tax attorneys who audit the estate tax returns. Those are the things they're looking for, and raising your awareness of them so that way you're preparing the estate tax return, you are minimizing your risk of audit. So there's, again, in our accounting phase, there are all kinds of potential pitfalls. And can you provide us some tips to minimize beneficiary complaints in the estate administration?
Let's start with whether it's better to have an informal accounting or a judicial accounting. An informal accounting is cheaper and faster. You can only have an informal accounting if you have competent beneficiaries all around, because an incompetent beneficiary can't release you. In the informal accounting context, it is a contractual release, right? All of the beneficiaries say, I hereby release you from liability for your acts as fiduciary of the trust or the estate. So, the first preference is going to be an informal accounting if you can do it. Sometimes the beneficiaries say, I'm not releasing you. Then you're forced to go to court. So there's two times you're forced to go to court. One, if you have an incapacitated beneficiary, an infant, judicially declared incapacitated person for whom a guardian has been appointed, a not declared incapacitated person, just somebody who couldn't possibly sign it because they don't have capacity, even if they haven't been adjudicated incompetent, okay? Let's assume that you are choosing your route. You have the ability to go judicial or contractual to obtain your release. Okay. You should be able to assess, if you've done your job, whether your accounting is going to draw any objections, and whether, as a matter of law, those objections might be sustained. Okay? To minimize the risk of objections, here are some guidelines which at this point in the lecture should be self-evident. Communication with your beneficiaries is key. They should be receiving from a prudent fiduciary periodic updates on the administration process. It should not be a mystery when it comes time to, when you render your account, when you say, here's what I've done. What's on that piece of paper should never be a mystery. Also, you can minimize objections and increase the likelihood of an informal accounting if you have your beneficiaries to consent to big transactions. Okay? If you have a big money transaction that you have to engage in as a fiduciary, go to the beneficiaries. Explain to them why you want to do what you want to do and obtain their informed consent. Okay? Now, those words have meaning, informed consent. If I just have a consent, I pass it off along and say, here, sign here. This is a consent to allow me to sell the house. That consent is not informed. It is not meaningful legally. It has to be informed consent in order to be binding upon the beneficiary who signed it, okay? Hire professionals, we've talked about that, but hire professionals whose fee structures and expertise are commensurate with the size of the trust or the estate and the complexity of its issues. Don't hire a top-tier firm to administer $1 million estate. Doesn't make sense. Don't hire a big accounting firm to administer $1 million estate. You can be sure you're going to draw objections to the fees. I'll be the first one to object that you hired above the need that you had. Okay. By hiring at the appropriate fee level, you're going to head off the complaints that the fees are too large. By hiring at the appropriate expertise level, you're going to ensure that the fiduciaries are receiving sound advice at a reasonable price. Okay? You should be able to dispose of those kinds of objections if you make those moves correctly. And to monitor your professionals. That means you have to be able to show that the decisions they were making were within the parameters that you set for investments, and that the parameters you set for investments were reasonable. Create a contemporaneous record for all important decisions. Don't hesitate to draft memos to the file that you can pull out of your back pocket when it comes to the accounting and there's a question about a particular action you took. Here's why I did it, and here's a contemporaneous memo explaining it. Why contemporaneous? One, because memories are what they are. And two, because on more than one occasion, courts have suggested that the rationale for a particular action was concocted after the fact to fit the ultimate set of circumstances. You want to make sure that you're never accused of that by making contemporaneous documentation. Make sure you have addressed all volatile asset issues as soon as they arise. You do not want to watch a crash and burn and have to explain that on the back end. So keep your eye out for that. If a beneficiary complains that a proposed course of action is self-interested or born of improper motives during the course of administration, take that head on. It may be prudent to seek a court order. This may be something that benefits me, but it's in the best interest of the estate, and the court has said that during the course of the estate's administration before the action is taken. You have removed the possibility that on the back end, after the transaction's complete, a beneficiary can come forward at the time of the accounting and said, he did this for his own damn good. It had nothing to do with the best interest of the estate. Take that objection away from them by going to the court early.
Okay, thanks. All right. So now let's move over to trustees. Again, for our executors/administrators, a lot of these responsibilities, there is a lot of overlap with trustee. But let's just kind of focus on our trustee as fiduciary and some common pitfalls. So in order to have a trustee, you got to have a trust. So let's kind of quickly do a little Law School 101 and do a review of a trust. So a trust is a very flexible tool used for a variety of purposes, both commercial and non-commercial. The trust is an essential and core part of modern estate planning practice, as it is used as an instrument for the gratuitous transfers of wealth. Our trust has three basic legal parties. One, our settlor/grantor/creator who creates the trust, our trustee who holds the legal title to the property, and the beneficiary for whose benefit the trustee holds title to and manages the trust property. So we have several people here in the audience. We have all kinds of trusts. It's kind of like different models of cars. Anybody want to share a few? Maybe. Okay. I mean, we can have a trust that holds real estate. We have our testamentary trust. When I think about last will and testament, that is a trust that's created under the will. And if you see a lot of late night TV, especially Susie Orman or or stuff that comes out of California and Florida. What of our favorite estate planning vehicle there? Anybody remember that? Our revocable living trust. Okay, that's another one. Now the revocable living trust, that is another way to pass. It's like what I call like a super will substitute. So instead of, you do have a will, but it's like a pour over will, because it lives up to its name and that it pours over anything that's not in the living trust into the living trust. Our living trust is, created by, our grantor. They're generally the sole trustee. Maybe there are with somebody else, and it's completely revocable and changeable. Okay. One of the main drivers of doing a revocable trust is to avoid probate. Now, in New York, that's not such a big deal. It's not having a revocable living trust is not the majority of estate planning. There are a lot of folks that do it, but it's not like everybody does it, or best practices, like I would say in California or Florida, where it is known to be the probate system is difficult, time-consuming, expensive. Everything that those late-night programs always say it is. So we have our revocable trust, the revocable living trust. Now we have charitable trusts. We have charitable remainder trust, charitable unit trust. They can also be in your will, or they can be created during your lifetime, irrevocable trusts. Some folks that do Medicaid planning, and I don't do Medicaid, it's outside the scope, but they may do irrevocable trusts to do some Medicaid planning, coordinating with the appropriate look-back period. So there's, and then we have our trust for our individuals, our grandchild's trust or our children's trust. They can be for a term of years, they can be for a lifetime. And then you have your dynasty trust that can go on for perpetuity, hence the name dynasty. And you would do that in a jurisdiction that has gotten rid of our rule against perpetuities. Remember that old from property law? Remember 21 years plus lives in being. Yes, I still remember one of my favorite illustrations of the rule against perpetuities, the fertile octogenarian. Now don't ask me that's what it means, but I just remember those words and I thought that was very interesting. So all different types of trusts, those are our basic parts. For the purposes of our lecture here today, our program, I'm really thinking about our testamentary trusts, our trusts that are created underneath the will, or our revocable trusts, or our trusts that are irrevocable trusts that are for the benefit of the family, particular child. You'll have your, in your typical will estate planning pattern, you'll have your credit shelter trust, which is the, we don't have the credit shelter anymore. We have the exemption amount, but that generally will hold the largest amount you can pass free of state and federal estate taxes. That's generally for the benefit of the surviving spouse and the descendants, commonly thought of as a sprinkle trust, so you can sprinkle all the monies between those beneficiaries. And then the remainder part, you often may see it going into a marital Q-tip trust. You might hear Q-tip, not the thing you clean your ear with, but it stands for qualified terminal interest property. It's meant to qualify for the unlimited marital deduction, and there's certain requirements under the Internal Revenue Code that you must to adhere to, so make sure you qualify for the unlimited marital deduction. So those are, and so our typical credit shelter trust and our typical marital trust, those will go for the lifetime generally of our surviving spouse, okay? And then the surviving spouse's death, the money gets distributed to generally the decedent's children is our common pattern. And then it will further provide in our estate plan that if any of those descendants are under a certain age, it'll be then held in further trusts for the benefit of our descendants. So there's a variety of different trusts out there. But again, our basic components are the same: our creator, our trustee, and our beneficiary. So when we have it under our will, our creator is our decedent, our testator, right? Okay, so again, many of our concepts that we've talked about for our executor and our administrator that we've discussed earlier also apply to the trustee as a fiduciary. We have our duty of loyalty, our duty of prudence, our duty of impartiality, and to inform and account to the beneficiaries. So, we do again have differences between, a trustee and our executor/administrator. And can you give us elaborate a little bit and explain any big differences in the fiduciary duties between our executor/administrator and a trustee?
Well, I have just a couple of small points on that, because the duties are largely the same. I mean, even the statutes apply to both executors and trustees. There are two big differences. One is that the trustee tends to have a lot more discretion in terms of distributing the funds. The executor is directed to pay out the funds to the named beneficiaries, typically. The trustee also has duties to the named beneficiaries, but may be given discretion as to when to pay income, whether to pay income, when to pay principal, and if the instrument wasn't broad enough in terms of discretion, statutes have cropped up that have given trustees the ability to circumvent the statutory provisions. We have now in New York a power to adjust between principal and income. So instrument doesn't provide, so what? I can still pay out some of my principal to the income beneficiary. Power to create a unit trust where I'm paying a specific amount. Bottom line is trustees have more discretion on the whole in terms of how much money they're paying over to the beneficiaries than executors do. And the other thing is, because an estate is a finite period of time, usually much shorter than a trust, the investment responsibilities play out differently. The same statute applies, but the investments tend to be kind of a simpler, more straightforward administration and distribution plan than is utilized in the trust context.
Okay, great, thanks. Now going back to our investment, because our trustee, they're going to have assets and they're going to be investing those assets for the benefit of the beneficiary and getting your investment advisor and getting an appropriate plan. Now our duty of investment is somewhat different, as the term of the job is generally longer for our trust than it is for the administration of the estate. So again, what I've mentioned earlier, our life cycle for the administration of the estate is generally, that I've seen for a taxable estate, 2.5 to 3 years. And the reason is not because we're sitting around and not actively working, but it's just kind of the way life is. It's kind of like one of my favorite examples is you got to renew your driver's license. No matter how organized you are and what time you show up and have all the paperwork, you're always going to be there for a good several hours. Okay. So with respect to the administration of the estate, when I mentioned about there's periods of activity and periods of inactivity, you're going to be right in the beginning. You're going to be probating your will. It's thinking about the will. You're going to be identifying all of your assets, valuing your assets, raising your cash, preserving your assets, paying off your creditors, and then the big one is you're going to be, assuming this is a taxable estate, you're going to be paying your estate taxes within 9 months from date of death. Very often, because think of the administration of the estate as kind of like almost like the termination of a company. You're really winding everything up, and there's just a lot of moving pieces in there. And when it comes down to estate tax liability, I want to make sure that I get every single thing out there. Okay. So very typically, even though my estate taxes are due within 9 months, most likely I'm going on automatic extension. You get an automatic 6-month extension, and it's just automatic. You don't need a reason, and you just get it. And generally, again, there's generally no big downside to going on the extension. If you know all of your information, you can file on time and pay it. Great, but typically, these things take time. There's time to forward the mail. If there's any bumps in the road with the estate administration, we don't get a fiduciary appointed. We can't get our assets and statements to do a proper collection of the assets. It's going to take some time. So there's a higher likelihood that we're going to go on automatic extension. Okay, so we get another 6 months. Then we're going to finally file our estate tax return. And remember, we've paid, and we want to make a very good high-level estimate on that amount. And I generally, do an estate tax return kind of like as I'm going along. We're collecting the assets, we're valuing the assets, we're putting all that information in. So then when it's time to pay my estate tax, I have a good hard number, and then I always like to add a little bit extra, depending on the size, depending what the estate is, for those surprises, those that found out, oh, there was an extra account out there, there was an asset, we wound up finding, getting something in the mail like, oh wow, we now saw that there was some interest in some real estate that somewhere else that we didn't know about. So I have a little bit of an extra, okay, in there. So we file our estate tax return. We have after our 6-month extension. But does our taxing authorities, do they immediately get back to us? What do you think? No, they don't. It takes time. So, because you're not the only name on the dance card. I typically tell the folks it takes about 6 to 9 months to get your response. You're either going to get an estate tax closing letter saying, we have accepted your return as filed, and keep this with all of your important records. Remember it talks about important record keeping that Anna mentioned? This is one of those things. This is a really important record to keep, okay? Your estate tax closing letter. Or you may get bad news, and that bad news is either a letter or typically a phone call. Hi, I am so-and-so from the Internal Revenue Service, and I am going to be auditing your estate tax return, and we're going to be working together. And that typically can take, a fair amount of time. It can extend the estate administration 9 months, a year or more, and then they'll give you a standard letter of all the things that they typically are going to want to ask for. Another important point when you're thinking about your estate tax return and the filing, and the person that audits your return, this is a very common misunderstanding. Oh, the estate tax auditor, like the person's a CPA with the green eye shade. Okay, they are an estate tax attorney. Okay, do not make that assumption. They're an estate tax attorney. These people are highly qualified, highly experienced, and they are estate tax attorneys. A person like me on the other side that have had years and years and years of experience to look out deductions that are no good, values of assets that are not proper, and then that's going to be things up for grabs. So, and it takes time for that. So that's why I'm saying that your typical life cycle for an estate is somewhere between 2.5 to 3 years, and it could be longer. Once you get audited, it could be a longer time. If there's any type of litigation that's involved, as well, longer. So if you have a non-taxable estate, it can be shorter. So common terms for our trusts are surviving spouse's life, which we'll see that in our marital trust and our typical credit shelter or bypass or family trust. And for a term of years, we typically see for a child. So it'll be in trust till they're 35 or 30. Or we'll see a lifetime, for the lifetime of the child. And on death, it'll go to their descendants. So, thinking about on the investments, and can you provide some guidance on some best practices for the trustee to implement their investment responsibilities? So for our trustees, given our term is generally much longer than it is for our estate.
Yep. Executors and trustees both are required to invest in accordance with the Prudent Investor Act in New York. That's 11-2.3. And the Prudent Investor Act says, here's all things you ought to consider when you're making investments on behalf of a trust or estate. Okay. They're just what you would think. Okay? The size of the trust, the duration of the trust term, the dispositive terms of the instrument, because if you're going to invest and it's all income to spouse, you want to make sure you have some assets in there that throw off some income, right? The needs of the beneficiaries, the general economic conditions in the market, the tax consequences of your decisions. all of those things are in the mix when you're making investment decisions, right? Executors have typically liquidated everything, right? That's what they've done. There's a new question about whether that's appropriate. At least one court has said, hey, executors, you're bound by this act too. You don't simply get to wholesale liquidate everything. Okay, open question. But where the estate's assets are pouring into a continuing trust of the kind Jill has talked about, the executors can't just act like executors typically would. They have to consider the eventual flow of those assets from the estate into the trust, right? And they have to employ a longer-term strategy for investment of those assets, okay? Hey, these assets are going to end up in a trust, and they're going to be administered for a 20 or 30-year period. So just wiping them out, cashing them out all in, doesn't make sense at all if you have a trust flowing under the will, okay? Funding trusts early makes sense. Don't wait to fund your trusts, because when you wait to fund your trusts and you leave those assets that are eventually going to be in the trust sitting in the estate, if there have been paper losses, they'll be on your executor's account. They will draw the attention of your beneficiaries. Get anything that's going to be held because it's on a long time horizon out from under the executor's hands into the trustee's hands, where it can sit until you're 20 years from now, you account again, and the values have gone up. Okay. Simpler point. Trustees are required by statute to diversify their assets unless they reasonably determine it's not in the beneficiary's best interest to do so. That can put you in a really bad position as a trustee if what you inherit is a closely held corporation. Okay? The decedent's pride and joy, and not a provision in the trust instrument that suggests you should be holding onto it. And yet expectation amongst all family members that that business will continue for generations in the trust. What is one to do when faced with a duty to diversify the trust assets? Trustees have to sit down with an investment advisor, we've talked about that, to determine which assets to retain and which assets to sell. I'm a trustee, I got to sell some assets, right? How am I going to invest? Generally speaking, from a global perspective, you should be investing across asset classes with low or negative correlations so that they're not all rising and falling together in the market, okay? Put some over here. So this asset's going to, when Europe's going crazy, this asset's coming down, and this asset's going up. You want offset, okay, by asset class. Make sure you're taking the terms of the trust into account when you're deciding what the assets are going to be. You can't invest in a vacuum. You have to say to the beneficiaries, what are your needs? What am I allowed to give you? How will I use the assets to provide for the needs of the beneficiaries over time? What about the tax consequences of sale? What if I have an asset with a huge gain built in? Okay? All of those things had to be taken into account. For God's sake, document your investment decisions in writing, not just the decisions, but the basis for them and the advice you got. Take notes of all of your meetings on investments and put it in the file. Okay. My personal preference is that my clients meet with their investment advisor at least quarterly. Okay? It's not enough to review trust investments once a year. It's not how you review your own investments, right? You look at those monthly statements. You got to look at it every month. But in terms of making your adjustments, at least quarterly, you have to sit down and meet about adjustments. When can you retain an undiversified portfolio, like the decedent's closely held business? There's not a ton of case law, but if you read the case law as a whole, you can discern some themes. If you cannot replicate through other investments the income stream that your closely held business is throwing off. I have a widow with big income needs. I'm to distribute all the income to her, and this closely held business is throwing off a ton of income. I can't replicate that. That's a justification for holding and not diversifying, right? If the tax consequences of sale are so onerous that after the payment of tax you're going to have a lot less money to play with, that's a justification. If the asset's value in the trust is worth far more than a diversified portfolio would be. So for example, I have a closely held business, but I can't sell it for the value it has to me because I have a 42% interest. I don't hold the majority share. It's worth a lot to me because it's throwing off income, but I can never sell it at that price. That's a rationale for continuing to hold. But you have to have a rationale for not diversifying. Okay.
So as Ann mentioned, our New York EPTL 11-2.3 has the Prudent Investor Act, which sets forth the prudent investor rule. And again, all of you out there in webcast land, take a look at your own state statute on this. Most likely there'll be something very similar. A trustee has a duty to invest and manage property held in a fiduciary capacity in accordance with the prudent investor standard, which I'm going to talk about in a little bit. Now, this standard is a rule of conduct and not, I want to repeat, not, underlying bold, a measurement of outcome or performance. Like Ann had mentioned, you're meeting with your investment advisor hopefully quarterly, you're taking detailed notes, the basis of your decisions, but you are not guaranteeing performance. It is a process, not guaranteed performance. So if I want to highlight one of those 3 things you all are going to remember in 6 months' time, remember this. When you are living up to the prudent investor rule, okay, under the Prudent Investor Act, it is the process. You are not guaranteeing performance. You have your process in place, you're a good investment advisor, you're meeting with them, you're taking notes, and you are rebalancing as they direct you to when they do. This is a facts and circumstances test, okay, where the trustee will not be liable to a beneficiary to the extent that the trustee has acted in substantial compliance with the prudent investor standard. What does that mean? That means that if you hired a good investment advisor and you're checking up with them and that you're meeting with them quarterly and you have the basis of all of your decisions in diversification or holding and the market tanks and you lose 40% in value, you have your process in place, you are not guaranteeing performance. Okay. Let's go a little into the details about more about the requirements of the prudent investor standard. Ann did touch on some of them. So you are going to first pursue an overall investment strategy to enable the trustee to make appropriate present and future distributions to or for the benefit of the beneficiaries under the terms of the trust and in accordance with the risk and return objectives reasonably suited to the trust investment portfolio. Okay. You're going to consider the size of the portfolio, the nature and anticipated duration of the trust. Is it for lifetime? Is it a term of years? Is it short-term, long-term? The liquidity needs, general economic conditions, effect of inflation or deflation, expected tax consequences of the investments, expected total return of the investment portfolio, and the needs of the beneficiaries to the extent the trustee knows them. Okay. You're going to diversify the assets unless it's determined that it is not in the interest of the beneficiaries to diversify, and Ann has given us some very good examples of why you may not want to. And determine which of the initial assets used to fund the trust should be retained or sold. So that's some of your basic requirements of your prudent investment standard. Okay. Common pitfalls in this area: improper investments, poor books and records for a trustee, loss in the value of trust assets, conflicts of interest, self-dealing, especially with the trustee beneficiary. It is not uncommon that when I see some of these family trusts, one of the co-trustees is also a beneficiary. Also, the failure to inform an account. So those are some of the common pitfalls. And do you have any other elaborations on some common pitfalls or some of the things that you've seen?
Investment-wise.
Or just in the administration of the trust. I mean, investments obviously is a big one.
Yeah. No, I think, well, given that nobody here is going to be a fiduciary anytime in the near future.
Anybody want to be fiduciary after hearing this? No. Remember, it's not an honor, it's a job where there is personal liability. Yes, okay, sorry. So.
Okay. We're going to do a little bit of ethics, because ethics can be fun. In the trust and estates world, ethics in the trust and estates world. Let's start with a vexing question. What are the obligations of counsel where counsel learns that his client, the executor, is planning to breach his fiduciary obligations? There is no great answer. There is an answer. It's a very unsatisfying answer. Okay. The first thing you're supposed to do, if you find out that your client, the fiduciary, is going to breach his fiduciary obligations, is say, cut it out. You may not do that. You, of course, can't help him. Can't help him breach fiduciary obligations, right? And if, after you say, cut it out, actually, the actual terms are, call upon the executor to act in accordance with his fiduciary obligations. Cut it out. If he doesn't cut it out, you're supposed to withdraw. Okay. The vexing part is you cannot disclose your client, the fiduciary's confidences or secrets to the beneficiaries. No warning may be given. The fiduciary walks into your office and says, you know what? I took $1 million out of the trust account and I bought myself a nice house. Put the money back, you're supposed to say. But you may not tell the beneficiaries that's what's happened. Okay. If you're a litigator like me and your client has lied to you and you have repeated that lie in an affidavit and submitted it to the court. Once you learn it is a lie, you have to encourage the client to correct the misstatement in the court document. If the client refuses, which you know that's going to happen, the lawyer must withdraw any misstatements he made to the court. Go to the court and say, I take it back, over the client's objections, although still you cannot reveal why that happened. What if you represent more than one fiduciary and there's a conflict between them? You agree with one fiduciary, you disagree with the other. What are your obligations as counsel to the multiple fiduciaries? You cannot represent one against the other. Even if one is so clearly right, you are required by law to walk away from both unless you obtain consent to represent one. What are the chances, after the conflict has developed, that one of the fiduciaries is going to go represent him? I'm that sure of myself. Doesn't happen. You can rectify this in your retainer letter, though. You can put what's going to happen in the event of conflict in your retainer letter. The question becomes, what do you put in your retainer letter? Anything goes, but here's my personal recommendation. Obtain advance consent from your multiple clients, your two fiduciaries, that all confidential communications are going to be shared. You tell me something you did, I get to tell him. Okay? And if either client refuses to allow disclosure, you're out. You're out. You'll withdraw from representation, and you will inform the clients, both of them, that a conflict has occurred. You can go further. You can say, I will tell the other guy what you said. I've seen it. But the problem with that is, when you're on your way out the door, dropping that big bomb it's not a pretty moment. Father and son, petitioning for probate. And The will gives money to the father, will gives money to the son. They're both your clients, co-petitioners. And another beneficiary comes forward and says, you're not entitled to any assets of the estate, father, because you killed your wife, the decedent. But the son believes in his father, and they come to you together, and then the father says, in a meeting between them, you know, I did kill her. I did it. At that point, do you want to go to the son and say, your father confessed to me? Do you want to say, I'm out of here. There's been a conflict. I cannot reconcile it. You need to each obtain separate representation. That's probably the cleaner way to go. I don't think when you suggested that you were going to tell the confidence that you were thinking of moments like that, but they can be harrowing. The easiest thing to do is say, there's a conflict between you, you each need to get separate counsel. Most of the time, the client who has not made the confidence to you figures out there's a problem and figures out what that problem is. That's my recommendation. Okay. Can an attorney draft a will in which he's named as beneficiary? Sometimes. The rules of professional conduct say you can never solicit a gift. You can draft an instrument if you are related to the testator. Okay? Your own family members can give you a gift in a will you draft, but it has to be a gift that results from a transaction that's fair and reasonable. Doesn't that seem a little strange? In fact, a reasonable lawyer has to conclude that that gift is fair and reasonable. ACTEC, which is a community of trust and estate specialists, says, be careful. Okay, you can make a gift to yourself. I'm drafting my father's will. Okay, I can make a gift to myself. Be careful about disproportionate class gifts. I'm drafting my father's will, and guess what? I'm getting it all. My siblings are getting nothing. That's not a will from an ethical perspective you ought to be drafting. If there is relative proportionality amongst the class, ethically, there is no prohibition. Can an attorney draft a will in which he's named as fiduciary? Yes, yes. Okay. But Rule 1.8c commentary says you have to advise the client of a couple of things. Okay? You have to advise the client that you have a financial interest in that appointment. You're going to get commissions. You have to advise the client that there are other candidates out there and that attorneys don't have a corner on that market. Okay? Your own kids can act, et cetera, et cetera. You have to advise the client of that. Now that's an ethical rule, but it's also a statute now in New York, okay? Because the New York legislature got a little tired of attorneys popping up as fiduciaries in wills all the time. So they enacted a statute, and they said, you have to have your client sign an acknowledgement. And let me tell you, I'm not a drafter, but I've heard it can be an awkward moment. Here's the acknowledgement. Mm-hmm. It says, I've informed my client, it's the client signing this, I've been informed that anybody can serve as executor. I've been informed that anybody who serves as executor is entitled to commissions. I've been informed that if I don't sign this document, my attorney as executor is only getting half his commissions. At that point, don't you think they're thinking twice about signing? If I don't sign this document, commissions are halved, okay? If my attorney serves as executor and also renders legal services, he gets both commissions and legal fees, okay? That's the acknowledgement that you're required to sign now if you want to get your full commissions and you drafted the instrument and you are an attorney, okay? That acknowledgement has to be in a separate document. Can't be in the will, can't be buried in the boilerplate of the will.
That's right.
Okay? It has to be signed by a witness. Courts have differed as to who that witness might be, with one surrogate, I know I'm on tape, but ridiculously holding that that the witness cannot be a person sitting in the law firm, a secretary, a paralegal. Well, where are you supposed to go to get that form signed if you can't do it in your own law firm? Okay. That disclosure, called a 2307A, has model forms. There's model forms in the statute. Use them. There is no reason to deviate from the language of the form as contained in the statute if you are an attorney, fiduciary, drafter. Okay. Can an attorney offer to act as executor or trustee? I'll do it. Can an attorney say that? Yep. If certain conditions are met. The client is competent. Well, there's no point in doing a will if the client's not competent, right? That's just a silly prong of the test. If there's been a long-standing relationship between the attorney and the client, don't do it for a new client, in other words. Don't have a client walk through the door and say, let me be your executor. Has to be a long-standing relationship, okay? And the client has to have some difficulty in selecting someone else, okay? Client appears to experience difficulty in selecting some other qualified, competent person to serve. In other words, the client doesn't have anybody else, okay? It's always more appropriate if the suggestion, you be my fiduciary, you be my executor, comes from the client, but it doesn't have to. You can see that they cannot identify someone to act in that role, and you can step up and offer. Under no circumstances may you try to convince them that you are the best man or woman from the job. Can an attorney enter into a contract with their client requiring that the lawyer be appointed as fiduciary under the will? That kind of answers itself, huh? No. No can do. Unenforceable. Can an attorney drafter named as an executor draft a provision into the will increasing his or her commission space? In other words, here's the commissions you would get by statute. I'd like more. I'd like you to put in your will that I get more. For example, I'd like you to put in your will that I get commissions on all assets that don't pass under the will. The ones that Jill tells the non-clients to go out and collect themselves. I'd like commissions on those as well. Theoretically, you can make any deal you like with the executor, but the case law establishes that courts will scrutinize those provisions, and if there's a way to knock them out by suggesting there's been overreaching or constructive fraud, courts are going to get you. Okay? And there are very well-respected practitioners who have tried this, who have done all they could, or all they thought they could, to protect themselves from courts knocking it out. From having the clients sign letters saying, I completely understand that there are going to be 3 commissions shared between 3 fiduciaries rather than the statutory 2. I completely understand that assets I've already disposed of during life are going to be subject to commissions at my death. I mean, and the courts have said, no, not enough disclosure, you know, and they've reached to find the things that they say have not been properly disclosed. Can an attorney representing the estate advise the surviving spouse of her right of election? Does everybody know what a right of election is?
Let's
Okay,
go over that.
Back one step. Right of election. I make a will and I leave everything to my son because I've never been that fond of my wife. And
this does happen.
yeah, basically every day of our lives. I've never been fond of her, you know, and you know, we never really moved toward the divorce thing because we were both a little lazy, and you know, okay.
This does happen.
We had other things going on, so my son gets it all. No, not under New York law. Under New York law, the wife has a statutory right, regardless of the wife or the husband, the surviving spouse. Has a right, regardless of what the will says, to take 1/3 of the net estate. It's New York's screw the will provision, okay? Public policy grounds, you cannot leave your spouse without any money at your death. Okay. If I'm the attorney representing the estate, can I tell the surviving spouse about her right of election? Inviting her to wreck the estate plan that's reflected in the will? I represent the estate. Can I do that? Yes, I can. I can tell the surviving spouse that she has a right of election, a statutory right of election. I can then invite her to retain independent counsel to pursue that for her. I can't help her out, because it is, as I noted, it is a exercise that contravenes the estate plan that I am here to defend, right? If the wife exercises her right of election, does she have to resign as executor? She's named as executor. She exercises her right of election. That's right. She does not have to resign as executor. She's exercising her against the will in her capacity as beneficiary. Once she has elected, her conflict is no greater than posed by her joint status as executor and beneficiary. She will go on to continue to administer the estate. Okay. Is an executor required to resign if the estate has a claim against him? The estate has a claim against the executor. Nope. Nope. Plenty of situations in which the estate has a discrete claim against the executor. The son has failed to pay back the loan made by the decedent to him. The estate has a claim for it. It doesn't mean he has to walk away. Okay? One of the other siblings will surely come forward and say, you owed Pop money, and you're going to pay it. And that sibling will seek limited letters for the purposes of pursuing that claim against the executor. Okay? If the executor has a claim against the estate, what happens? At the time of Pop's death, he owed me $10,000, and I want it. You can pursue it. You're executor, you can pursue that claim against Pop's estate, but you have to get court approval to pay it. You cannot be the terminating force behind that payment, because, you know, you're a little self-motivated to say it's a valid debt. What if the attorney drafter commits malpractice in putting together the estate plan? What are his obligations?
No such thing, right?
Pardon me?
No such thing, right? The client's dead.
Oh, not any longer. Okay, so there's a whole new universe here in New York.
Citadel of privity.
Yeah, the privity has cracked.
Yes.
And in fact, the executor does have a claim for malpractice against the attorney drafter. What are the attorney drafter's obligations? Well, let's assume for a second that nobody's figured out that he's made a mistake yet. He has an obligation to the client, now dead, and thus to the client's estate, to report any significant error or omission that could give rise to a malpractice claim. He's got to step forward and volunteer the information. Okay? If somebody comes forward and says, I think you made a big mistake, sir. If he believes at the outset that his own work was negligent and that the claim of malpractice is colorable, he may not have anything to do with the estate. He's got to walk away. If he thinks there is no apparent basis, good faith belief, no apparent basis for a claim of malpractice, he gets to stay in the picture. Okay? He may represent the executor after the client's death, the attorney. But let's say you start out like that. You say, I didn't really do anything wrong. I don't need to step away from the plate. I can represent the executor in the ongoing administration of the estate. And then he comes to believe during the course of that representation that maybe he did something wrong. It's got to go. Okay? Because it's a conflict of interest to represent the estate when the estate has a claim against you that goes to the core of the estate's administration, whether it's the tax plan or the estate plan or anything else. What if the attorney can cure the malpractice? Does he still have the obligation to disclose? Nope. If it can be cured, there's no significant risk that his professional judgment on behalf of his client will be compromised. He's in. The end.
Yes. Well, thank you all for listening, and I hope you remember your 3 things in 6 months' time.